If you woke up this morning with a knot in your stomach after seeing those alarming headlines and viral posts about deportation raids, I want you to take a deep breath right now. I know how frightening this feels. I know the uncertainty keeps you up at night. I know you are worried about yourself, your family, and your future. You came to this video looking for truth, and that is exactly what I am going to give you today. No panic, no exaggeration. Just honest, clear, verified facts so you can understand what is really happening and what you need to do. Please subscribe to Immigration Path USA for the latest updates about immigration news and changes so you can stay informed with accurate and reliable information. Now let us get into exactly what the Department of Homeland Security has officially confirmed this week. What these new enforcement priorities actually mean, who is genuinely affected, and most importantly, what you should do right now based on your specific situation. I am going to walk you through everything step by step in plain, simple language so that by the end of this video you will have clarity instead of confusion. Here is what we know as of today, January 19th, 2026. On January 15th and 16th, the Department of Homeland Security officially published updated enforcement priorities and expanded the categories for expedited removal. This is not a rumor. This is not speculation. This was published in the Federal Register, which is the official government publication for new rules and regulations. That makes it real, official, and currently in effect. Now, what does this actually mean? Let me explain it to you clearly. Expedited removal is a legal process that allows immigration officers to deport certain individuals quickly without going through the full immigration court process. Previously, expedited removal was primarily used for people apprehended very close to the border or within a short time after entering the country. What has changed now is that the government has expanded where and when expedited removal can be applied. According to the new guidance, expedited removal can now be used anywhere in the United States, not just near the border, for individuals who cannot prove they have been continuously present in the country for at least 2 years. This is a significant expansion, and I want you to understand exactly what it means. If you are someone who entered the United States without inspection, meaning without going through an official port of entry, and you cannot demonstrate that you have been here for at least 2 years, you may now be subject to expedited removal if encountered by immigration officers. This applies anywhere in the country, not just in border states. At the same time, Immigration and Customs Enforcement, known as ICE, has begun increased interior enforcement operations. There have been confirmed reports of enforcement activity in California, Texas, Georgia, New York, and Illinois. These operations are real. They are happening. But I need you to understand something very important. Not everyone is being targeted equally. There are specific priority categories, and I am going to explain exactly who falls into those categories based on what DHS has officially published. According to the official DHS guidance released this week, the highest priority for enforcement are individuals who pose a threat to national security. The second priority category includes individuals who have been convicted of serious criminal offenses. The third priority includes individuals who have already received final orders of removal and have not complied with those orders. And the fourth priority includes individuals who recently crossed the border without authorization. Now, let me be very clear about something. If you are an undocumented person who has been living in the United States for many years, who has no criminal history, who has not been ordered deported before, and who is simply living your life, working, taking care of your family, the current published priorities do not place you in the highest enforcement categories. That does not mean you have zero risk. But it does mean that the government has stated that its resources will be focused primarily on the categories I just described. However, and this is important, I want you to understand the difference between published priorities and what happens in real-world enforcement situations. When ICE officers conduct operations, they have the legal authority to arrest anyone they encounter who is in violation of immigration law, even if that person was not the original target of the operation. This is sometimes called collateral arrests. So while the published priorities give us an understanding of where the government says it will focus, individual encounters can still result in arrest and removal proceedings for people outside those priority categories. Now, let me address some of the rumors and misinformation that have been spreading like wildfire on social media this week, because I know many of you have seen posts and videos that have caused extreme panic. First rumor I need to address. Some people are claiming that green card holders are being targeted for deportation. Let me be absolutely clear about this. Lawful permanent residents, meaning people who hold valid green cards, are not the target of these enforcement operations unless they have committed serious crimes that make them deportable under immigration law. Simply holding a green card does not put you at risk in these operations. Your green card gives you the legal right to live and work in the United States permanently. However, if you are a green card holder and you have been convicted of certain crimes, particularly aggravated felonies or crimes involving moral turpitude, you may have separate legal issues that you should discuss with an immigration attorney. Second rumor I need to address. There are viral posts claiming that USCIS is canceling approved green card applications or revoking work permits for people with pending cases. As of today, there is no official USCIS announcement or Federal Register publication that confirms any mass cancellation of approved petitions or pending applications for people who are lawfully present and going through the proper legal process. If your case is pending with USCIS, continue to monitor your case status online, respond to any requests for evidence, and attend all scheduled appointments. Unless you receive official communication directly from USCIS stating otherwise, your case is still being processed according to normal procedures. Third rumor I want to address. Some people are saying that if you have a pending asylum case, you will be deported immediately. This is not accurate. If you have a pending asylum case and you have not been ordered removed, you still have the legal right to remain in the United States while your case is being decided. However, if you have a final order of removal that you did not appeal or your appeals were denied, that is a different situation. In that case, you may be considered a priority for enforcement. If you are unsure about the status of your case, I strongly encourage you to consult with an immigration attorney who can review your specific records. Now, let me give you some practical guidance based on your specific situation. If you are undocumented and you have been living in the United States for many years without any criminal history or prior deportation orders, the most important thing you can do right now is consult with a qualified immigration attorney to see if there are any pathways to legal status that apply to you. Some people have options they do not even know about. There are provisions for victims of crimes. There are family-based options. There are provisions for people who have been in the country for extended periods. An attorney can review your specific circumstances and tell you if you have any options. If you have a final order of removal, meaning an immigration judge ordered you deported and you did not leave, this is a serious situation. You are in one of the priority categories. I strongly urge you to consult with an immigration attorney immediately to discuss whether there is any possibility of reopening your case, filing a motion, or exploring any form of relief. Do not ignore this. Get legal help now. If you are a visa holder, whether you are on a student visa, work visa, tourist visa, or any other non-immigrant status, make sure your status is valid and has not expired. If your visa has expired but your status is still valid based on your I-94, make sure you understand the difference. Carry documentation with you that proves your legal status. If you are working on an employment-based visa, make sure your employer records are in order and that you are complying with all the terms of your visa. If you are a green card holder, as I mentioned earlier, you are not the target of these operations unless you have criminal convictions that create deportability issues. However, now more than ever, if you are eligible to apply for United States citizenship through naturalization, I encourage you to seriously consider doing so. Citizenship provides the highest level of protection. Once you become a citizen, you cannot be deported. If you have been a green card holder for the required period of time and you meet all the other requirements, consider starting your naturalization process. Let me also talk about your rights if you are ever approached or stopped by immigration officers. Under the United States Constitution, everyone in this country, regardless of immigration status, has certain rights. You have the right to remain silent. You do not have to answer questions about where you were born, your immigration status, or how you entered the country. You can simply say, "I am exercising my right to remain silent." You have the right to refuse consent to a search of your belongings, your car, or your home unless the officer has a warrant. If an officer asks to search, you can say, "I do not consent to a search." If officers enter your home, you have the right to ask if they have a warrant. A valid warrant for your home must be signed by a judge and must have the correct address. ICE administrative warrants do not give officers the right to enter your home without your consent. However, I need to be honest with you. In real-world situations, these encounters can be frightening and unpredictable. My advice is to remain calm. Do not run. Do not argue. Do not provide false documents and do not physically resist. If you are arrested, ask for an attorney and do not sign any documents you do not understand. Remember that anything you say can be used in your case. I want to take a moment to remind you of something very important. The content I am sharing with you today is general information based on publicly available official government sources. This is not personal legal advice for your specific situation. Every immigration case is different, and the only way to get advice tailored to your circumstances is to consult with a licensed immigration attorney who can review your case in detail. If you cannot afford an attorney, there are nonprofit legal organizations in many cities that provide free or low-cost immigration legal help. Please seek qualified help if you need it. I also want to gently remind you that immigration law does not change overnight based on social media posts or political speeches. For a new law to take effect, it must go through Congress and be signed by the President. For a new regulation to take effect, it generally must go through a formal rulemaking process and be published in the Federal Register. Executive orders can be issued more quickly, but they can also be challenged in court. What I am telling you today is based on what has officially been published and implemented. If anything changes, I will bring you an immediate update on this channel. In the coming days and weeks, I know there will be more headlines, more viral posts, and more uncertainty. I want you to know that this channel will be here to give you the truth. I will always tell you what is confirmed, what is rumor, what is proposed, and what is actually law. That is my commitment to you. Before I go, I want to speak directly to you for a moment. I know you came to this country with hopes and dreams. I know you have worked hard, sacrificed, and built a life here. Whatever your situation is, you deserve to have accurate information so you can make the best decisions for yourself and your family. Please do not panic. Please do not make decisions based on fear or viral posts. Take a breath, get informed, and take action based on facts. If this video helped you understand what is really happening, please take a moment to subscribe to Immigration Path USA and tap the notification bell so you never miss an important update. Give this video a thumbs up if you found it useful, because that helps other people in our community find this information too. And please share this video with your friends, family members, coworkers, and anyone you know who might be confused or worried right now. Sometimes the best thing we can do is help each other stay informed. I also want to hear from you. Leave a comment below and tell me what topics you want me to cover next. What questions are on your mind? What are you most worried about? I read your comments, and your feedback helps me create content that serves your needs. Thank you so much for being here. Thank you for trusting this channel to bring you the truth. Stay strong, stay informed, and I will see you in the next video.